If you've watched my channel for any length of time by now, you'll know that one of my pet hates is people using their mobile phone while they're driving. Not just because it's against the law, but because it harms people, and because I've been to court to argue over what a child's injuries are worth when they've been involved in a collision. And I'd rather not have to do that, and I'd rather no one have to do that. But nonetheless, it happens because people use their mobile phone while they're driving. So not that this is going to be a lecture video, but I've had lots of emails of reports just recently where people have been threatened with a lawsuit, or they've actually been sued for alleged breach of data protection laws and various other things. You may remember I did a video about Ashley Neal not too long ago where he was threatened with a lawsuit for breach of data protection and for defamation. This was an hour-long video with our friend Alan Robertshaw, and we discussed those issues in length because defamation is one of Alan's specialties as well. So with that in mind, I wanted to do a video for those that might get threatened with a lawsuit or have been threatened with a lawsuit, who are out and about with their cycle cams, their dash cams. They want to report these things to the police or what have you, and are worried about lawsuits. Not that this can be taken as legal advice. It is my guidance, my views, and a generic walkthrough. Let's get into it. Welcome back to the channel. So you'll remember that I've done these videos a number of times before. I also talked about the Ring doorbell cameras where you may be incoming to the data protection laws where your cameras capture footage outside of the curtilage of your property. There's a number of case law decisions that impact upon this, and we have, confusingly, the UK retained version of GDPR, and the cases, such as they were on exit day, are applicable, subject to the fact that the higher courts can disapply them where they choose. And so it's all a bit confusing, and law should not be confusing. So that's what my channel is here for, to help you to understand the law. So please make sure you smash that like button and subscribe at any point that you find this video useful. So in many cases, people are out and about with dash cams, cycle cams, safety cams, whatever you want to call them, recording for their own personal uses. Now, I'll make the distinction here that I'm talking primarily about individuals and not businesses. There's a fairly distinct difference between the two, although many of the principles will be the same. Just as a brief word on that point, businesses, if you are capturing any kind of footage of anybody, data from anybody, just register with the ICO. It's far simpler, and put in data protection systems to comply with the principles so that you're not going to be in breach of data protection law. I talk about all of those principles in another video, which I won't go into in great depth here, as I do in another video, but essentially the information's got to be no more than necessary. You don't do much more with it than it's collected for in the first place. It's stored securely. You comply with data subject access requests to provide it, correct it if it's wrong, delete it in some situations, and so on. I'll deal with that in greater detail in another video, which I will try to remember to link in the description below. And if I forget, you will remind me, because I usually forget. However, let's get back to the point. So I'm primarily talking about individuals that have cameras. And now, to explain this a little bit further, I'm going to talk about the distinction between CCTV cameras and dash cams. There is a distinction. Now, many lawyers have argued that CCTV cameras and dash cams are to be considered one and the same thing under GDPR and so on. And whilst argued eloquently in those that I've seen, ultimately, in my view, that's just not the case. And it's not just my view, it's the view of the ICO. Because if I take you now to this slide here and talk about CCTV, there is a distinct difference between the CCTV and dashcam footage and how it should be treated according to law. Now, for those that don't know, and it's not obvious, the ICO, the Information Commissioner's Office, is the regulatory body to police, if you like, data protection compliance in the UK, both with individuals where data protection law is applicable, and certainly, and for the most part, businesses, organizations, public bodies, and so on. Now, it talks about CCTV systems here. And I'll put this link in the description below as well, but I'm going to go through a brief overview of what this means in relation to some other cases. So the use of any recording equipment, such as CCTV, as it says here, for example, smart doorbells and all those things that capture video, are going to be subject to data protection law if they will capture something outside of the curtilage of your own property. Now, this is not just the ICO's view, but this is also something that was picked up in a European case here, which hopefully I've remained highlighted. It's down here somewhere. I didn't highlight it. It's around here somewhere. Here we go. To the extent that the video surveillance, such as that the issue of main proceedings covered eventually partly a public space directed outwards from the private setting and the person processing the data in the manner cannot be regarded as purely personal and household. Why is that important? Well, what are we talking about and why is it important? What we're talking about is where you have a fixed camera, a fixed static camera, capturing something outside the bounds of your own property. This means that it is not a wholly pure or purely personal and household activity. Why is that important? Well, if it is something that you're capturing purely for your own personal household activity, you're exempt from GDPR. But as per this case here, and as is echoed in the ICO's guidance, if it is captured outside of yours and towards a public area, such as your neighbors and so on, then it is not purely household and GDPR will apply. That doesn't mean you're breaking the law necessarily. It means you need to comply with the law. So there's a distinction there. But staying on point for a moment, if it is a purely household activity, you are exempt from GDPR and it doesn't apply at all. Now, there's a distinct argument over what is or is not a purely household activity. And for example, if let's say you covertly record a phone call with an insurance company because with respect to you watching, if this applies to you, you cannot keep up with the conversation adequately enough to retain all of the information yourself or even make notes to that effect, you might want to record it so that you have a full copy of that conversation that you can refer back to. So that, for example, you can avail yourself of the cooling off period if you choose to exercise that right to withdraw from that contract based on something you didn't like from the conversation, but you could only do so by listening back to it. And you want to record it for that purpose. So long as you don't then publish that on the internet and send it to lots of other people, that is going to be a purely household activity. Now, there is an argument that publishing it on the internet is also not necessarily bringing it outside of the bounds of a household activity. There are some examples even provided that is, for example, sharing photographs on social media and that kind of thing is still a household activity, although some case law decisions in the EU have contradicted that. But this is where we get into a bit of a grey area. But staying on point, if you've covertly recorded that conversation for your own personal uses, that is your household exemption. That's perfectly fine. Distinction in the question comes when you're using a dash cam and you're out in public. Now, the reason there's a distinction here is it's not a fixed camera and you're out in public. It is not fixed surveillance. Whilst it is not your own property, you're out in public. There are principles at play where out in public you do not have, as in the general public does not have a automatic right to privacy in a public place. That is on occasion decided differently. If, for example, a person who is famous and notable and well known is out with a small child in a coffee shop, then the courts are going to find that there's a reasonable expectation of privacy there, i.e. leave them alone. But in general, if you're out in public, your number plate, your car number plate, your face walking around, you don't have an automatic right to privacy in those places. And because that is not a fixed camera, in my humble view as a barrister, that is not going to bring it outside of the bounds of a wholly personal household activity, because it's not a fixed static surveillance camera. And it seems that the ICO agrees with me, because when we look through here, we have a list of rules that apply to CCTV if it's recording something outside of the bounds of your property. But, and I'll come back to some examples in a moment, but the ICO's view is as follows: these rules only apply to fixed cameras. They do not cover roaming cameras, such as drones or dashboard cameras, dash cams, as long as the drone or dash cam is used only for your domestic or household purpose. Now, straight away, some people will say, well, if you're posting things to YouTube, for example, and you're making money by doing so, for example, then it's commercial, therefore it's not household. And yes, that's perfectly fine. However, those people, by the way, if you're doing that, should register with the ICO just so that you are registered as a data controller and you comply with data protection and so on. But then even in that situation, it doesn't mean you're breaking the law. so long as you have a reason to be processing the data. For example, you interview somebody, you've got their consent, or at least implied consent, that you're going to use their footage and publish it. There might be a contractual reason. There might be some other legitimate reason. You might be a journalist, and there might be a journalist exemption. It might be artistic or literary in nature, and you might have some lawful basis for processing that footage, recording, data, whatever it might be. All the principles still apply. It's got to be no more than necessary, no longer than necessary, stored securely, etc., etc. But if you are an individual using one of these drone cameras, head cameras, dash cams, whatever, then you're not breaching data protection laws if you're using it for a household purpose. But then what is a household purpose? Now, one question which will be for the court to answer, because there is no definitive law on this. I will come back to some law cases in a moment that have been decided, that have been a test case, and there are some overlaps and application and analysis that can be done with that case. I did a long video on that, which I'll come back to in a moment. But in this case, I have been told about many cases where someone has been reported to the police for road traffic offences such as breach of Regulation 110 because they had their phone in their hand. They've even been given admissions effectively as part of a claim against them that the person involved had the camera in their hand and they were doing something with it while they were driving. And they were convicted of such because they reported to the police. So if they were to appeal that, for example, but there is clear evidence that they're doing it, there is no defense. If you have the phone in your hand and you're driving and you're doing something with it, then you are breaking these regulations. And this is the common one that people are reporting online at the moment. I say online to the police, I should specify. And it's breach of Regulation 110, which covers pretty much everything for any device that you could possibly do if it's in your hand. A handheld device is anything that is capable of transmitting and receiving data, whether or not those capabilities are enabled. So it doesn't have to be doing it at that time. It just has to be capable of it. If it's a device like that, which includes phones, obviously, and even watches and things like that, anything like that is capable of transmitting and receiving data, whether or not. So if you're using it, touching it, and doing any of these things, the word using involves illuminating the screen, checking the time, checking notifications, unlocking the device, making or receiving calls, sending or receiving messages or written content, uploading, sending, receiving, utilizing the camera, sound recording, any kind of sound functionality whatsoever. If it's in your hand, you're in breach of these regulations. So that is quite simple. So that is what people are outside with their safety cams, dash cams, whatever it might be, filming and capturing somebody in the act, as I suppose you could say, doing these things. Now, the question for the court to answer, this would be for a test case, and I will stake my line in the sand as to what I think the decision of any such test case should be. The question is, does it remain within a household activity if you have personally recorded this footage and then report it to the police? Now, in my view, if you report that to the police, you're not publishing it to the public at large. You're not putting it online. It's not on YouTube or whatever. There are separate reasons why I think that should be okay, and I'll come back to those in a moment. There's a lot of coming back to things. So if I forget, remind me and I'll do another video. But I'll come bact to those. But reporting it to the police is neither publishing it online, sharing it with friends, or all of these kind of things. It is to an extent processing this information, this data, but for a legitimate interest. And there is a provision for a legitimate basis, which is under Article 6 of GDPR, even if GDPR applies, which is processing necessary for the purposes of legitimate interest pursued by the control or third party. And here's part of what a lot of people will argue, where such interests are overridden, except where such interests are overridden by the interests of fundamental rights and freedoms of the data subject. So in that situation, it very much depends on how that's been shared and with whom it's been shared. If it's with the police, it is my view that does not, the fundamental rights and freedoms do not override the interest of reporting that to the police. But that's where GDPR does apply. And so even if it does apply, there is a legitimate basis there. But on the basis that there is a valid reason for sharing the information, it is my view that a court should uphold, as I say, there is no test case for this. It is one area that is very slightly grey at the moment. But it is my view that any test case should come to the conclusion that if you report it to the police, much like you would report anything else to the police, a break into your home or whatever it might be. If, for example, if you know who it is that broke into your home and you took a photograph of them in your home, it's not a fixed camera. It is, for any other description, a roaming camera, because you pick up your phone, you take a camera. You have captured that person's personal data if you've captured their face on camera. And let's say you know who it is, or you think the police know who it is, or it turns out that the police know who it is. If a court were to find that you were a data controller and didn't comply with data protection laws and therefore in breach of data protection because you reported that to the police, that is absurd. Because if somebody broke into your house and you took a photograph, or your fixed cameras in the house, within your house, either on the boundaries, within the boundaries rather, or within the insides of your house, if you took footage of that person and reported it to the police, and the police followed it up and they were prosecuted for burglary and successfully convicted, if they were then to sue you for breach of data protection because you've shared that information with the police, that is absurd. And so, in my humble opinion, which I express strongly, I admit, that would be absurd. So it must be the case that, extrapolating that out now, out of the home into a public place, remember, being in a public place, you don't have an automatic right to privacy in a public place. Now, we're talking about, or we have been talking about, simple, I say simple, they're fairly serious in my view, but simple road traffic offences. Whilst some may argue that it is only a minor road traffic offence, I would come back and say that the CPS, the Crown Prosecution Service website, under dangerous driving, not just careless or inconsiderate driving, but dangerous driving, and bearing in mind that there is a separate section here that talks about breach of Regulation 110, causing or permitting a person to drive using a handheld mobile telephone or other device. Looking at dangerous driving in particular, one of the examples where it says here, some typical examples from court cases of dangerous driving are using a handheld phone or other equipment. So allow me, first of all, I'll make that bigger so you can see it more clearly, but allow me to emphasize that using a handheld mobile phone whilst driving on the CPS website, which is the authority for bringing public prosecutions, they give an example of using a handheld phone under the heading of dangerous driving. So I have seen arguments by lawyers where this is only a minor road traffic offence. With respect, I fundamentally disagree. It is not a minor offence to be using a phone whilst you're driving. And this offence is whatever you're doing with it, whether you are, as I say, whether you are illuminating the screen, checking the time, unlocking the device, and so on and so on. And so in my view, in my humble view, if you are out recording with your cycle cam, your dash cam, or any kind of vlog cam, whatever it is you're doing, in your household capacity as an individual recording for your own safety, in case you get hit, in case someone crashes into you, or even fraudulently tries to crash into you, or you have an argument, or you're attacked, or whatever your reason might be, it doesn't matter. In my view, if in doing so, much as you would for your home CCTV, recording your home in case somebody breaks into your house, if you then report that footage to the police, share that footage with the police, it is not bringing it outside of a household activity, in my view. However, let's talk about the situation where, let's say, somebody may be coming under data protection laws because it is outside of a household activity. The case is Fairhurst and Woodard, which I did an extensive video on previously, which involved several such cameras. The principal point of this case, which involved both data protection breaches and harassment, which I go into a great deal of depth for on my other video, which I will link in the description below. The distinction here is that these cameras included footage outside of the curtilage of the defendant's property, which did engage data protection laws. Now, then you raise the questions of data protection and whether you have complied with data protection laws, such as recording no more than is reasonably necessary, using it for purposes which is no more than reasonably necessary or gathered for in the first place, and whether you've misused that information and all of that sort of stuff. So I go into a great deal of depth in that video about these principles, so I will link that in the description below. But coming back to another principle, such as those that might be out in the purposes of journalism, you might be a vlogger, you might be a so-called auditor. I don't like the term, but people refer to auditing as going out and filming things. This is arguably journalistic, possibly even artistic in nature, and in some sense, at least academic. My videos here arguably are several different things. Journalism in one sense that I report news sometimes, academic in that I'm certainly trying to educate you to understand law, artistic sometimes I suppose, and possibly sometimes even literary when I'm making my own content for you to learn from. So mine could be all of these things, and many other people could have other purposes for using it. So these are special purposes, and when we talk about special purposes here, subparagraph 3 applies to the processing of personal data carried out for the special purposes if the processing is carried out with a view to the publication of person of journalistic, academic, artistic, literary, and so on. And the listed GDPR provisions do not apply to the extent that the controller reasonably believes that the application of those provisions would be incompatible with the special purposes. So if it is incompatible with any of these purposes, the GDPR provisions do not apply. But broadly speaking, if you are brought outside of the bounds of a household purpose, you can still have a legitimate interest, which is where the processing is necessary for the legitimate interests of you or of a third party, unless there's a good reason to protect the individual's personal data, which overrides those interests. Now, again, that comes into play where some people have said that their right to privacy and to protect their own personal data comes over and overrides the police interest in receiving that information to prosecute them. I don't agree. I don't think that is right, and I just don't think that is an argument that a court would uphold. But as I say, until there is a test case, we won't know. So we will need to wait and find out. There are also some copyright issues that come into play here, but we will talk about those much more on Art and Media Law with me, myself, Black Belt Barrister, and the Alan Robert Shaw. And yes, that rhymes. So please do hit subscribe down below for that as well, because we go into a lot of different copyright aspects and media law aspects there as well, all of which are useful and relevant. But my overarching conclusion is that if and when there is a test case, it has to be right that the court finds that anybody who is recording for their own personal uses that then report it to the police cannot be held to be in breach of data protection laws. Because, as I say, if we use the example of you using home CCTV, which is only within the bounds of your curtilage and not outside, which would engage data protection, and then you go on to report that to the police, it cannot be right that you're held to be in breach of data protection. But likewise, if someone is initially incidentally caught committing an offence, and then the data is then gathered to provide it to the police, again, I just don't think a court should be upholding a breach of data protection for that individual. But I suspect there's going to be a few, at least, threats like this and a few cases like this. And ultimately, I think there will be a test case for something like this. I think ultimately a circuit judge will probably take one of these on, just like they did in this other case that I mentioned here, the Fairhurst and Woodard case, which I will link in the description below. To go through all of that in great detail. So I hope you found that a useful overview. Please do smash the like button and subscribe. We are coming up on 300,000 subscribers. I'm very grateful to you for watching and for subscribing, and I'll see you next time.